Good morning, everyone, and welcome to our spring property update. Today is Thursday, the 10th of April, and I'm John Perrott, head of the commercial property team here at Myerson. Thank you all for joining us online this morning. We don't have time to take questions during the webinar, I'm afraid, but please do get in touch afterwards if you have any questions or if you'd like to discuss anything raised in the webinar with us. We last met back in October for our annual update. We were all awaiting the autumn budget at that point. The Chancellor, Rachel Reeves, did, of course, make a number of changes affecting those with property interests. Our residential property team have been incredibly busy for the past few months as a result of the announcement that the first-time buyer relief band would change from 1st of April this year. Many people were disappointed that the Chancellor didn't use the recent spring statement to extend the stamp duty deadline for those rushing to complete their property purchases. I think our residential team have now just about recovered from the deluge of transactions where there were chains involving first-time buyers, which obviously had to complete by the end of March. So the spring statement brought no new surprises on business and capital taxes, but also there was no further clarity on the implementation of proposed inheritance tax changes. For clients with property portfolios who are looking to undertake estate and succession planning, the lack of further clarity around inheritance tax means a number of key planning questions remain unanswered. You will recall that the autumn budget announced amendments to the rules on pensions, bringing unused pension pots into an estate for IHT purposes from April 2027. And there were also restrictions to business property relief and agricultural property relief coming in April 2026. The changes will affect a wide range of individuals, including property investors, and the lack of further detail on how the rules will actually be implemented is quite frustrating. There's also the concern that this adds another layer of complexity and complication to a recovering property market. The Chancellor said in her statement that some 1.3 million new homes will be delivered by the end of this Parliament. She said this was within touching distance of the 1.5 million target the government set itself, but some are disappointed that this target has been reduced already. There was a real focus on the economic benefit that this increased activity in the house building sector and the wider associated sectors will bring. £625 million will be spent in England over the next 4 years to boost existing schemes to train workers in the construction sector. Yeah. The skills shortage following Brexit and COVID had led to a big question mark, really, over the ability of this sector to bring forward the planned growth. So hopefully this will go some way to closing that gap. Perhaps the most relevant news from around the time of the spring statement was actually the news that the rate of inflation has reduced to 2.8%. If this leads to a cut in the Bank of England base rate in May, it could actually help transactions to start flowing more than anything announced by the Chancellor. Geopolitics have obviously stepped in during the past few months to dampen down some of the optimism we might all have been feeling towards the end of 2024. The start of the new Trump presidency and the subsequent uncertainty regarding Ukraine, Russia, and the US, as well as the threat of tariffs on goods being exported to the US, may mean that investors will continue to watch and wait for a little bit longer. Transactions are still ongoing and keeping us very busy here at Myerson, but the return to the speed of transactions as we knew it a couple of years ago is still a work in progress. We are hopeful that things will settle down into a new normal and that the encouraging noises we've been hearing regarding deals being done will become self-fulfilling prophecies. So, turning to this morning's speakers, we will firstly be hearing from Sarah Dabek. Sarah will be talking about high street rental auctions, which are another government scheme which aims to stimulate the economy and revitalise high streets up and down the country. With Altrincham having once been named the worst high street in Britain, though obviously things have changed here very significantly since that, we're very much aware of the impact that vacant retail space can have on a town centre, and it will be interesting to see what difference schemes like these can make over time. Laura Pyle will then provide an update on recent case law which is of interest to property owners and occupiers. It's quite a varied roundup, including issues as diverse as the restructuring of a chain of cinemas and a property infested with moths. Finally, Heather Adams will be talking to us about buy-to-let investment in the residential sector, how that's going in the current landscape, and how we can help. Heather will also be talking about property incorporations, something which her team are extremely experienced in dealing with in conjunction with our corporate team. So I will now hand over to Sarah. Thank you.
Thanks, Joe, and good morning, everyone. I'm Sarah Dabeck, a Senior Associate in the Real Estate team here at Myerson. In this section of the webinar, I'm going to be talking about the newly introduced High Street Rental Auctions scheme. I'm going to touch upon what High Street Rental Auctions are, how they work, and how the scheme impacts landlords and tenants. High streets have faced a significant decline in recent years, and data from the final quarter of 2023 revealed that nationally, 1 in every 7 high street shops were closed. In order to tackle long-term vacancies on high streets and in town centres, the High Street Rental Auctions scheme was introduced by the government on the 2nd of December 2024 under the Levelling Up and Regeneration Act 2023. The purpose of this scheme is to help revitalise vacant commercial properties on high streets and in town centres, and to allow local authorities to intervene when commercial properties have been left empty for an extended period by forcing a rental auction process. Not every vacant commercial property will automatically be eligible for a high street rental auction, and certain conditions must be met before a local authority can proceed with an auction. For example, the property must be located on a designated high street or within a designated town centre. These designated areas are specifically identified by local authorities as priority zones for regeneration. The property must also be suitable for high street use. This includes a variety of business types such as shops, offices, bars, restaurants, cafes, public entertainment or recreation venues, and communal spaces. It's worth noting that premises which are used wholly or mainly as warehouses are specifically excluded as a high street use. To be eligible, the property must have been unoccupied for a continuous period of at least 12 months, or for a total of at least 366 days non-continuously within a rolling 24-month period. The property's occupation must also be likely to provide economic, social, or environmental benefits to the local area. High street rental auctions will not be suitable for all high street premises. For example, large former department stores may be subject to long-term, complex redevelopment plans and may be negatively impacted by being subject to inclusion in the auction scheme. In addition, given the likely significance of repair costs payable by the landlord, premises which are affected by significant issues such as dangerous structures notice, contain combustible cladding, or have serious condensation or damp issues are likely to be outside the scope of the scheme. So let's take a look at how the auction process works. The high street rental auction process begins with a 10 to 12 week notice period and then a 12-week auction period. The 10 to 12-week notice period begins with a local authority serving an initial notice on the landlord of premises that they have identified as eligible for a high street rental auction. During this notice period, the landlord will have the chance to make their own arrangements to enter into a tenancy, which must be granted to a tenant within 8 weeks of the serving of the initial notice. If the landlord fails to enter into its own tenancy within the 8-week period, the local authority may serve a final notice informing the landlord of its intention to run a high street rental auction in relation to the premises. The landlord has the chance to serve a counter notice, objecting to the final notice, and appeal. Assuming the final notice is not withdrawn by the local authority following counter notice or successfully appealed by the landlord, the process will then move to the auction period. After the initial notice period has passed, the local authority then has 12 weeks to auction the premises and exchange contracts for a tenancy. This is the auction period. During weeks 1 to 4 of the auction period, the local authority and the landlord are expected to engage with each other to create the auction pack, with the landlord being required to provide information about the premises and being afforded the opportunity to make representations on the proposed terms of the contract and the tenancy agreement. The contract and tenancy agreement, along with several other documents, will make up the auction pack. A marketing period operating during weeks 5 to 9 at a minimum will then follow, where interested parties can register their bid with the local authority. In weeks 10 to 12, the local authority must serve the bids on the landlord before a successful bidder is chosen. The auction period concludes when a contract is exchanged between the successful bidder and the landlord. If a landlord refuses to proceed, the local authority has the power to enter into the tenancy agreement on the landlord's behalf. At auction, the successful bidder will enter into two legal agreements with the landlord. The first is the contract, which governs the landlord's required works prior to the tenancy commencing, and the second is the tenancy agreement itself, which will set out the specific obligations on the tenant and landlord during the term of the tenancy. So you might be wondering what works may be documented in the contract as being required by the landlord. Well, at the beginning of the auction period, the local authority will have conducted a survey of the premises to ascertain a list of works required from the landlord to be carried out at the landlord's own cost for the premises to reach what they call a minimum standard. The landlord must provide access to the local authority for the survey, and if they fail to do so, the local authority may proceed to enter the premises without consent. Minimum standard means being in a safe and secure condition and with any significant occupational risks either removed or managed. Examples include no significant water ingress or leaking, all internal and external doors operating safely, all external windows capable of ventilation or emergency escape, mains water, electric and gas connected, and toilets and hand washing facilities provided. The landlord must also ensure compliance with energy efficiency requirements and that the property has a valid EPC rating in order to be legally let. The landlord will have 3 months from exchange to carry out and complete the works. Should the landlord fail to carry out the required works, the tenant will be able to rely on remedies set out in the tenancy agreement to ensure compliance so that the tenant can operate their business in the way intended when entering the auction. The remedies include the tenant carrying out the landlord's works itself at its own cost and deducting the costs incurred from the rent payable under the tenancy agreement, the ability to terminate the tenancy agreement, or a liquidated damages claim for £55 for each day that the landlord's works continue after the 3-month period expires. Following completion of any required landlord's works, the tenancy agreement will then be granted. The form of tenancy agreement will be in a standard form which has been specifically designed for the High Street rental auction scheme, and some of the key provisions will include a length of term between 1 and 5 years, rent payable monthly in advance on the first day of each month, exclusion from the Landlord and Tenant Act 1954, meaning the tenant will not have statutory renewal rights at the end of the term, a fixed 4-week rent-free period for the tenant's fit-out works, repair obligations will be limited to a schedule of condition, the ability for the tenant to assign the whole of the tenancy with the landlord's consent, but all of the dealings prohibited, and a rent deposit of £1,000 or equal to 3 months' rent, whichever is higher. If any third-party consents would normally be required, for example, from a superior landlord or a bank, the tenancy will be deemed to have been granted with those express consents obtained. Therefore, the local authority is not required to apply for or obtain any such consents. In terms of auction costs, the local authority may require the tenant to pay its legal costs, search fees, and survey costs as part of the consideration for the grant of the tenancy. The local authority will otherwise be required to cover all auction costs for which it will receive funding from the government. In terms of where the scheme is up to with implementation, several local authorities have been identified as the initial early adopters and have been given funding and powers to start implementing in their areas. These include Blackpool, Bradford, and Stoke-on-Trent. While these local authorities are actively preparing to implement the scheme, specific examples of properties that have undergone the auction process are not yet available. As the programme progresses, more detailed outcomes are expected to emerge. The introduction of the High Street rental auction scheme may be controversial for landlords, as it infringes on freedoms to select tenants, set rental values, and deal with properties as they desire. However, with the stark data that 1 in 7 high street shops lie vacant nationwide, there is clear incentive for the government to introduce the legislation as part of an attempt to revitalise high streets and prevent properties remaining empty for extended periods of time. So that's everything I have to cover on the High Street rental auction scheme today. Thank you for listening, and I will now hand you over to Laura.
Thank you very much, Sarah, and good morning, everybody. So as Jo said, today I'm going to take you through some of the recent cases that are of note. So what we're going to look at today, well, we're going to look at UK Commercial Property Finance Holdings Limited and Sini UK Limited, which concern side letters and restructuring plans.
We're also going to look at the Woodward Fisher case, which you may have seen in the press, and relates to a moth infestation of a property in London and whether the seller misrepresented the position when they sold the property. We're then going to look at Hanstone Investments Limited and Abbey Group Limited, which relates to the request for an injunction to prevent a building being built that would interfere with the flow of light to the claimant's property. We'll then move on to MVL Properties 2017 Limited and the Leadmill Limited case, which is a lease renewal matter where the landlord sought to rely on ground G. And then finally, we'll look at another lease renewal matter, which is Sick and Malik, where the landlord sought to rely on ground F. So, firstly, let's have a look at UK Commercial Property Finance Holdings Limited and the Sini UK Limited matter. So what's the background to this case? Well, UK Commercial Property Finance Holdings were Sini UK Limited's landlord. The landlord and the tenant agreed by way of side letters compromises to the lease liabilities, and in consideration of those compromises, the tenant agreed not to seek to make any further amendments to the leases or seek further compromises for the next 2 to 3 years. The tenant subsequently instigated restructuring plans and sought to include the leases with the landlord in those plans. The tenant's position was that many of the properties that it occupied were over-rented, and that if the restructuring plans were not approved, it would be unable to meet its rental obligations, and as such would enter into administration. The landlord claimed that in seeking to include the leases, the tenant was in breach of the undertakings given in the side letters. They therefore applied for injunctive relief to ensure that they were not included. The tenant claimed that the approval of the plans would generate cost savings, which would ensure that the company was able to continue as a going concern. The tenant also claimed that the plans were designed to ensure that creditors would not be any worse off than in an insolvency. The court was asked to decide whether the conditions for sanctioning the plans were satisfied. So what was the decision? Well, the court applied a 3-stage test when considering this matter. And it had to assess whether the conditions were satisfied. So the first stage was the satisfaction of the no worse off test, i.e. that the creditors were no worse off under this plan than they would be in the alternative. And in this case, the court found that the alternative was an insolvent administration, and the plans had been formulated to ensure that no creditors were worse off. The second stage of the test was approval of the plan by at least one class of creditors. And in this case, the court found that the secured lenders had voted in favour of the plans. And then finally, the third stage was whether in all the circumstances the court should exercise its discretion to sanction the plan. And in this case, the court had to assess whether it was fair to force the plans on dissenting creditors, and the court found that the plans were fair in their treatment of creditors. However, the court did identify what they called a tension between the equitable jurisdiction to enforce a negative covenant to exclude particular creditors and the application of the pari passu principle, which required all unsecured creditors in an insolvency process to share equally any available assets of the company in proportion to the debts due to each creditor. So what are the takeaway points for this case? Well, the case shows that agreements between landlords and tenants to avoid the pitfalls of the insolvency process are not immune from the provisions of a restructuring plan. Creditors, such as landlords, should therefore take advice immediately regarding their voting and other rights in such circumstances. Formal opposition to restructuring plans should be filed as soon as possible, rather than relying on claims for injunctive relief. And we're currently waiting to confirmation as to whether this case will go to the Court of Appeal, but we'll keep you updated. So now moving on to the Woodward Fisher case. So what's the background to this case? Well, whilst this case is in relation to residential property, it's received quite significant press attention, as you've probably seen, and the principle can be applied to commercial property, so we thought that it was worth a mention. So this case relates to the sale of a £32.5 million property in London, which completed in May 2019. From early 2018, contractors had visited the property on several occasions and had undertaken numerous treatments in relation to a moth infestation in the insulation of the building. Now, the relevant inquiries and the seller's responses were as follows. So inquiry 2.1 says, has the property ever been affected by woodworm, dry rot, or other timber infestation or decay, defects in drainage, water pipes, gas pipes, or electrical wiring, damp, subsidence, landslip or heave, any structural building or drainage defect, vermin infestation or asbestos. And the answer given was, the seller is not aware of any such matters affecting the property since the renovation and extension works were undertaken and completed, but has not had the property surveyed for such matters, so no warranty can be given in this regard, and the buyer must rely on the results of its own survey, inspection, and professional advice. Enquiry 2.2 was, please supply a copy of any report concerning any matter referred to in Enquiry 2.1 above, or otherwise concerning the fabric of the property. And the answer given was, save as may have been disclosed in the documentation provided, there are none. Inquiry 2.3 said, is the seller aware of any defects in the property which are not apparent on inspection due to the presence of furniture, carpets, cupboards, etc.? And the answer given was, the seller is not aware of any such defect, but has not had the property surveyed for such defects, so no warranty can be given in this regard, and the buyer must rely on the results of its own survey, inspection, and professional advice. The purchaser claimed that the seller had misrepresented the position in their responses to the inquiries and was entitled to rescind the contract, and the seller denied the replies were misrepresentations. So what was the decision of the court? Well, the court found in favour of the purchaser, and that A, in relation to Inquiry 2.1, the defendant's contractors had confirmed an infestation of moths. Moths fell under the dictionary definition as vermin, and therefore the seller could not say there was no infestation without misrepresenting the position. The seller had been reckless in making his statement. The court found, secondly, that in relation to Inquiry 2.2, the contractor's reports forming part of the quotes constituted reports relating to the fabric of the property, and the seller had knowingly made a false statement. And then finally, in relation to Inquiry 2.3, defects were not simply in relation to the structure of the building, and the infestation was a defect which was not apparent on inspection, and again the seller had knowingly made a false statement. As such, the seller was liable for fraudulent misrepresentation, and the contract was rescinded, with an order for the purchase price and damages being made to the purchaser. So what are the takeaway points from this case? Well, the carrier temptor or buyer beware principle is well known in property transactions. However, this case is a reminder that sellers should carefully assess the inquiries and ensure that their responses are honest. It is correct that there is no duty to disclose on the seller, except to the extent that a failure to disclose would make information which otherwise given to a buyer misleading or incomplete. Simply stating that the seller is not aware will not protect the seller from a misrepresentation claim in such circumstances. Usually a contract is not rescinded after it has been completed, but if equitable, it is a remedy that a purchaser can pursue. If there has been a significant delay, equity will prevent this remedy, but in this case the period between completion and proceedings being issued was not such that it was inequitable to grant rescission. Equity will prevent rescission if the parties cannot be restored to their original positions, but in this case, when paid off the mortgage, the seller was not immediately able to return the purchase price to the purchaser. However, he had assets of over £20 million. Rescission was therefore ordered, subject to a lien in favour of the claimants for the amount owing. The judge in this case appeared to indicate that a purchaser's experts or legal advisors were entitled to rely on misrepresentations when advising their client and making recommendations regarding the purchase. Now, we understand that the seller in this case is considering his options in terms of an appeal, so watch this space. So now we'll move on to our next case, which is Hanstone Investments Limited and Abbey Group Limited. So what's the background to this one? Well, the defendant was a housing association erecting a 4-storey building. The claimant was an adjoining landowner who alleged that the building would interfere with the flow of light into its land. The claimant was concerned that if an interim injunction was not made, the build would proceed and the defendant would seek to rely on its completion in defending a permanent injunction at trial. However, the judge allayed these concerns by ordering an expedited trial and the defendant agreeing not to put forward argument based on the progression of the build at trial. So what was the decision? Well, the judge found that damages would be an adequate remedy for the interference. This was on the basis that the claimant was an investment owner whose tenants would not be impacted by light interference. As such, any diminution in value of the property could be adequately compensated by damages. The judge also found that when considering whether an interim injunction would be an appropriate remedy, on the balance of convenience, it would not be, due to the fact that planning permission had been granted several years before the development started. The development was in the public interest, and there had been no material objections from the claimant's occupying tenant. So the takeaway points to this, well, I'm sure it will brighten developers' days, and this case has emphasised the importance of the impact of the interference on the defendant and indicates that the courts will consider whether there is a loss of business as a result of interference and therefore an impact on livelihoods. The courts will also look at whether the public interest would be affected by granting an injunction, as would be the case here, where the development was for affordable housing. Judges will also look at the time period between planning permission being granted and injunctive relief being sought. A long delay works against the claimant, and therefore potential claimants should look to bring proceedings as soon as possible after becoming aware of a potential interference. And landlords must also make full use of any covenants in leases requiring tenants to take all steps that the landlord reasonably requires to remove encroachments or obstructions, as complaints by a tenant will assist in the landlord's claim. So now moving on to MVL Properties 2017 Limited and the Leadmill Limited case. So the background to this one is that the defendant in this case was a tenant of a music venue in Sheffield. The landlord had owned the property for 5.5 years and served a Section 25 notice on the tenant opposing a renewal lease on ground G, which is where they intend to occupy the property themselves. Now, the landlord provided various forms of evidence in support of its position, including an undertaking to the court to fit out the premises, the incursion of significant sums in obtaining planning permission for refurbishment works, obtaining a licence for the premises, together with a new trademark for the business. The tenant's repairing obligation was limited to a schedule of condition, which also set out the tenant's fixtures and fittings, which the tenant was entitled but not obliged to remove at the term end date. The tenant argued that it would remove the fixtures and fittings, and that coupled with the financial expenditure to the landlord of refitting the premises, which was estimated to be in the region of £2.1 million, and paying considerable statutory compensation, would make the project unviable. However, the landlord produced evidence to the effect that it had funds available to fund the project by shareholder loans or capital reserves. So what did the court decide? Well, the court found that the landlord's evidence supported its intention to occupy the premises for the purposes of its business, and also indicated that the landlord had the funds available to complete the project. In addition, occupation for the purposes of carrying out the fit-out works in itself was occupation for the purposes of a business, as required by Ground G. The court therefore ordered the termination of the tenancy. So what are the takeaway points from this case, and why have we highlighted it in today's webinar? Well, opposed lease renewals have subjective and objective elements. Subjectively, the landlord must demonstrate to the court that it has an intention to occupy the premises. Undertakings, such as the one provided in this case, are strong evidence of that intention. Objectively, the landlord must be able to achieve the occupation. Evidence in the form of planning permissions and financial backing is required to satisfy this element. However, the court's not required to assess whether a project is financially viable, only that the landlord is capable of achieving its objective. This case also addresses whether a landlord could take over the business of a sitting tenant. The court affirmed previous case law, which found that it was permissible for a landlord to use Ground G to take over a tenant's site. Tenants were protected to some degree by the 5-year rule, which prevented landlords from taking up occupation within 5 years of purchasing a site. The tenant also made submissions that their goodwill was property, which was being appropriated by the landlord in contravention of Article 1 of the First Protocol to the European Convention on Human Rights. However, the court found that the 1954 Act balanced the rights of the landlord and the tenant, and the rights were not infringed. So then finally, we'll have a look at the Sick and Malik case. So the background to this one, the tenant in this case held a 25-year lease of a property from which they ran a restaurant. The landlord served an opposed Section 25 notice on ground F, which is the redevelopment ground. The tenant issued lease renewal proceedings, but during the course of those proceedings fell into arrears of rent. The landlord peaceably re-entered the property and the tenant made an application for relief from forfeiture. The County Court judge granted relief on the condition that the rent up to the date of peaceable re-entry was paid, together with 50% of the rent due between re-entry and relief being granted, on the basis that the landlord had had possession of the property since the date of re-entry. However, in this case, the landlord had not made use of the premises between the re-entry and relief and had strongly contested the application. The landlord appealed that decision, and the appeal was heard by the High Court. So what was decided? Well, the High Court allowed the landlord's appeal. It reiterated that relief is only normally granted on terms that all arrears of rent and costs are discharged up to the date of relief being granted, and that there is no discretion. So what are the takeaway points from this one? Well, landlords will be reassured by this decision, as it supports their entitlement to rent up to the date of relief. However, the court found that if the landlord had made use of the premises, there may have been grounds for a reduction, as if relief is granted, the landlord is entitled to be restored to the position it would have been in but for the forfeiture. This involves the full amount of arrears being paid, but the landlord giving credit for any benefits it enjoyed due to the re-entry. Landlords should be aware of this when considering their use of the property after forfeiture. So that's the end of my presentation today, and I hope you found it useful. I'll now hand you over to Heather.
Hi, I'm Heather Adams, partner and head of the residential property department here at Myerson. I work closely alongside both Joe Perrett and Laura Pyle, who are partners and heads of the respective real estate and real estate litigation teams, who you've already heard from this morning. I'm going to speak to you about investing in residential property, as my team have seen a significant increase in the number of clients that we now act for in purchasing residential properties, for the sole purpose of letting these out and receiving an income in return. Letting out property is often seen as a low-risk investment with a reliable source of income. There is also then the added opportunity to make a capital gain when you come to sell the property in the future, as and when it suits you. We act for both individuals and companies purchasing properties, as buying in a company name is often a tax-efficient way of receiving income and lowering any tax burden. There are a few things to consider when you are looking to purchase a buy-to-let property. The first thing I would say would be to do your sums and make sure that your rental income is more than sufficient to cover your costs and provide some income on top for you. Also, make an assessment as to how easy it will be to sell the property in the future when you make that decision to cash in. Location and available amenities in the vicinity of any property are key to attracting the right tenant or buyer, and we often see properties being purchased within the catchment areas for the most popular schools, particularly in the South Manchester area, as an example where we are located. You may also wish to consider the age of the building and whether you're likely to have to incur regular and significant cost in keeping it in a satisfactory level of repair. Maintenance will be your responsibility as landlord and not that of any tenants that are at that point in situ. The energy efficiency rating given on the Energy Performance Certificate, known as the EPC, also needs to be of a level of at least E to comply with current letting legislation. It had been proposed that from this year, any new tenancies would require that a property had an EPC rating of C or above. However, those proposed changes have been scrapped for the time being. If you were to acquire a property with an EPC rating below E, then you will have to fund improvements to the property yourself, but this will be subject to a cap in spending of £3,500 including VAT. If it's not possible to increase the rating to E or above for the capped amount of £3,500, then you can register for an all improvements made exemption. Where possible, we would of course advise that you purchase a property that already meets the required rating for energy efficiency, as the costs of bringing the property to standard and the downtime where you might not be able to let the property could be too prohibitive. Tenants could also be more difficult to find if the property has a low EPC rating, as it will mean higher fuel bills for them. And second point, you need to determine how you're going to fund the purchase. If you require lending to be able to purchase your buy-to-let investment, there are a broad range of lenders you could approach. Buy-to-let mortgages tend to have many additional conditions attached to them, such as things like you can never personally occupy that property, nor can any member of your family. They will be required to be let on formal assured short-hold tenancies, usually for periods of no more than 6 months. Buy-to-let mortgage products often require a larger deposit than if you were buying a property as your own home. However, it might be possible for you to obtain a mortgage on an interest-only basis. This would mean lower monthly payments to be made, with the intention being that as and when you no longer require that rental income or wish to dispose of the property, the increase in value of that property will be more than sufficient to repay the original capital loan and provide some additional profit for you from the sale. If you're purchasing your buy-to-let investment in the name of a company, your lender will often require that you enter into a personal guarantee as additional security for the company's borrowing. It's rare that we see any buy-to-let mortgage products issued to a company without this condition within it. One of the main reasons for purchasing it in a company name could be to limit your liability and your risk, but then having to provide a personal guarantee reverses this. If your lender permits, we are able to advise on the personal guarantee for you, as well as acting on the purchase, as we simply ensure a different solicitor within the team acts for the directors in their personal capacity. Some of the other types of special conditions we see contained within buy-to-let mortgage offers would be matters such as ensuring that there are appropriate planning consents, licenses and building control certificates for works carried out to the property that may have been made to convert it into a lettable space. These are more detailed again if the property was previously a larger home that's been subdivided, not by way of creating individual dwellings or flats, but with the intention to be let on a room-by-room basis. These are known as houses in multiple occupation, or HMOs, and the rooms will then share amenities such as kitchens or bathrooms. Another point to note with potential HMO purchasing opportunities is that many local authorities are able to restrict the general permitted development rules, so that this type of development or conversion is limited and is especially notable in student areas. The requirements for HMOs may also need to be licensed, in addition to obtaining planning permission for that change of use, and these can be onerous and take a significant period of time to obtain. So another factor to consider if you're looking at purchasing that type of property. There are many positives to purchasing a buy-to-let property, and one of those is its tax treatment, and in particular the tax treatment of both income and any capital gain when you dispose of the property in the future, particularly where bought in a company name. We're of course not tax advisors, we are lawyers, and as such we would always recommend that you seek specialist advice on this point to decide not only whether to purchase a property in your personal name or a company name, but also how and when to dispose of the property, and how any income and capital gains will be treated. We can advise you on the additional rates of stamp duty land tax, SDLT, or if the property is in Wales, land transaction tax, which is LTT, that you'll be liable for when purchasing any buy-to-let property. Unless you don't own any other property when you buy your first buy-to-let investment, if buying in a personal name, then it's usual that for any investment purchase you will pay the additional rates of stamp duty, which are 5% above the standard rates that are payable. LTT rates do differ slightly, but work on the same principles. In addition, if you're buying in a company name and the price is over £500,000, then unless the company qualifies for a particular relief by virtue of its purpose being for property investment, there's an even higher rate of stamp duty payable and some further ongoing annual tax implications, but you would need to take specialist advice on that point. We have seen a notable increase in individuals who have operated a letting business as either a married couple or within a family, creating a company and incorporating their property business into that company. If certain requirements are met on incorporation, which usually includes satisfactory evidence that you were conducting that business as a genuine partnership, then there'll be no SDLT or capital gains tax liabilities when the properties are transferred from an individual's name to that new company. We work closely with some specialist advisors in this area and specialist mortgage advisors to ensure that any portfolios with existing mortgages can be refinanced at the same time as the incorporation process is taking place. We also work closely with our corporate colleagues in relation to these transactions. And if we can assist in any way, then please don't hesitate to get in touch with me or any member of the residential team, and we can point you in the right direction to obtain some initial guidance and advice on the process if this is of interest to you. Finally, just another point to note, if you do wish to transfer a property that's currently in your individual name into a newly formed company, not as partner of an incorporation, then even if the consideration shown as a director's loan to the company or transferred for a stated price less than its market value, you will be liable for stamp duty at additional rates based on its full market value. There will also be some further administrative matters required, as special company resolutions in relation to this particular type of transaction are required to be recorded. Once you've set up your buy-to-let investment portfolio, then we can also offer an additional service here at Myerson, and that we will upload all of your title documents and other relevant information in respect of each property to our property portal, which you can access at any time. If you then encounter any issues with tenants going forward, our real estate litigation department can also assist you with those. So thank you for your time today, and I will pass you back to Jo.
Thank you, Heather. So that's all we've got time for this morning. I do hope you found the webinar interesting and informative. As I mentioned at the beginning, if you do have any questions, please don't hesitate to either call or drop any of us an email. You will see all of our contact details set out on the slide. The webinar and slides will be emailed to you all after today, so please do feel free to share with anyone you think might be interested in having a watch. As always, if you've got any topics you would like us to cover in future webinars, please do drop us a line about that as well. And finally, just to mention, Laura and I will be attending UK Reef in May again this year. So please do let us know if you're going to be there. It would be lovely to meet up for a drink and a catch up. We're hoping that the weather is better this year and that nipping wasn't a sign of things to come with the weather. So just all that remains to say is thank you all very much for joining us and enjoy the rest of your day.